Bill Cosby back in court today for his trial on aggravated indecent assault charges. Prosecutors claim Cosby drugged and molested former Temple University employee Andrea Constand in 2004. Cosby has pleaded not guilty. Prosecutors called an assistant at a talent agency in the 90s as their first witness. Kelly Johnson claims that Cosby drugged and took advantage of her without her consent. Prosecutors arguing that Johnson experienced a situation similar to Andrea Constand. The defense, though, attacked Johnson's memory of that timeline using a 1996 workers' compensation deposition as part of that. Johnson told the defense her memory was better back then. She is the only other accuser who is allowed to testify in this case. We have learned the prosecution just called a Canadian detective who took down the police report about Constand's sexual offense claim back in January of 2005. So the big question, of course, is when will Andrea Constand take the stand? Could she testify today? What sort of strategy is unfolding here for both the defense and the prosecution? Here to help us sort that out, defense attorney John Q. Kelly and prosecutor Wendy Patrick joining us both on the story. Good to have both of you here with us. As we look at the strategy here, it seems to be understandable why the prosecution would put this other accuser on the stand first, but we've learned that the civil attorneys and also the family of Andrea Constand in court today, according to our Jean Casares. As a prosecutor, Wendy, would you put Andrea Constand up there on the stand so early on?
Probably not, Erica. It's a great question because what the prosecution team is doing is setting the scene. Remember, this case is in a court of law, not the case in the court of public opinion. We're all used to hearing 50+ victims, etc. There's only one other victim that's going to be able to testify here. So with this patterns make the predator thief that the prosecution is trying to establish, they have to be very strategic as to how they set the background before putting on their star witness, which of course is Ms. Constand herself.
The defense is obviously going to be strategic as well, John, in terms of how they're cross-examining. And they were tough. They're being aggressive. They're being really tough on her. Does it ever change the approach, though, when you're dealing with someone who says, look, I was the victim of an assault here. I was violated.
Yeah. Well, I don't think so. I think when you're a defense attorney and your job is to confront the witnesses, challenge them, you can't be, unless it's a strategic decision, you can't be timid, you can't be shy. You've got to show the jury you believe in your client's position, and you've got to challenge the witnesses. And they've come out both barrels with the people that have testified so far, and they're not being shy, and they're calling them out on their recollection, their memories, and their timelines and things like that, as well they should.
And that's a major issue, Wendy, because it all comes down obviously to credibility. You need the jury to believe you, to believe that this is exactly what happened. And if there are holes in that timeline from both the other alleged accuser who was put on the stand and also they were talking about some holes dealing with the timeline that the officer put forth, this Canadian detective. How do you handle that as the prosecution?
Erica, it's so tricky because I used to be a criminal defense attorney. I used to have John's job. And it's very true. You've got to be very careful. Cross-examination is the great engine of truth, as we say. But you can totally alienate the jury by going too hard, particularly in a sexual assault case, at the victim. So it remains to be seen whether the hard strategies they're using with the other witnesses are going to be appropriate with Ms. Constand herself. Now, obviously, it's going to depend in part on what she says, but they've got to be very careful in making sure that a jury doesn't paint with a bad brush simply because they don't like the lawyer's strategy. It's all about finding a way to both ingratiate a client to the jury, but also get to the truth. So it's going to be more difficult with Ms. Constand than with any of these other witnesses.
John, Bill Cosby has now publicly said in a radio interview, I'm not going to testify.
He can't
testify. If you were his attorney, how displeased would you be with your client?
Well, I think he said in prior interviews, too, that his lawyers have already told him he's not going to be testifying. And I think the prosecution, I think everybody that knows anything about the legal proceeding like this would know he would not testify. As soon as he got up there and was questioned about his deposition testimony about providing quaaludes to other women and things like that, it would open the door to all these other incidences where the women were not allowed to testify. That would open the door, and they could probably all come in then. So there's just no way he can testify in this instance.
What do you ultimately see this boiling down to? I'll let you both answer that. John, you first.
I think that factually the prosecution has the elements of their case. You might see a little jury nullification, meaning there wasn't violence. It was a long time ago. This woman presumably got a boatload of money, and her motives might be questioned a little bit. Cosby's 79, blind, and they might walk him.
they might walk him. What do you think, Wendy?
You know, justice delayed is not justice denied. Not in a case like this, where there are so many other of the victims that are watching this testimony. Now, it's going to be a tougher case than it has been in the court of public opinion, for sure. But ultimately, you know, it's also going to come down to whether or not Cosby testifies. Let me say one thing about that. He doesn't have to decide till the very last minute. It might come down to client control because he gave an interview to Smerconish over the weekend. So you've got to think, you know, that's probably one of the reasons the jury is sequestered. But ultimately, there are sufficient facts there to have a conviction, and hopefully that'll be the result.
We'll continue to watch it. Wendy Patrick, John Q. Kelly, great to have both of you with us today.
Sure.
Thank you.
Thanks, Sarah.